The coveted last slot of the day here. Thanks a lot for sticking it out with us late in the day. My name is Brian Cunningham. I'm a lawyer in Denver, Colorado. My law partner Forrest Morgan and I run a law practice and Homeland Security, information security consulting firm in Denver, Colorado. And from 2002 to 2004, I was the deputy legal advisor at the National Security Council in Washington at the White House. And so was involved in developing a lot of the information security and homeland security laws and policies. Only the good parts, the bad parts were all done by somebody else. I recognize that we've got a very highly technical audience here. I'm sure most of you are far more technical than we are. I'd like to get an idea of how many of you are information security consultants as opposed to working for institutions that hire information security consultants. Who's the consultants here? Okay. All right. Very good. Well, let me start off. I'm not going to say anything very technical, but I did have a statistic I wanted to run by you. I always like to throw in a little science at the beginning. You may not be aware of this, but the National Academy of Science has actually started using lawyers instead of white rats for their experiments. And it turns out there's 3 reasons for that. The first one is actually more lawyers available than there are rats. The second reason is they've learned it's possible, bless you, for the scientists to become emotionally attached to the rat. But the most important reason, there's just certain things you can't get a rat to do. So with that, especially for those of you who are now sitting through your second and third lawyers of the afternoon, we appreciate it. This is the disclaimer that we always give, that even though we're talking about legal issues, nobody should rely on what we say as legal advice, not because it's not good, although I suppose some people might argue that point too, but because in order to give legal advice, you have to be in a lawyer-client relationship with individual people. You can't rely on what we say because you came to this meeting. That is a photograph of the White House Situation Room. I should say quickly that is not the President and his staff discussing information security. I believe that picture is actually from 9/11. But I put it here because to emphasize the degree of seriousness with which the national leadership takes issues of information security as national and homeland security issues beyond just the obvious economic impacts of information security problems. They actually view it, I think quite correctly, as a national security issue as well, and I'll explain why. The quote there is just to indicate that what would normally happen, we worked across a little street in a building called the Eisenhower Executive Office Building. And what would happen is you get called over to a meeting in the White House Situation Room, and they would call you on open line. And rather than say what the meeting was about, they would say they have a situation, which told you nothing other than you better be over there in about 5 minutes or less. And that happened several times with regard to information security. Now, thankfully, not with any actual major cybersecurity, cyber terrorism event, but there were a few close calls. And here's what used to keep us awake at night. Essentially, as I said, beyond the economic, risk, what the government is worried about, which you'll see articulated in the National Cyber Strategy, bless you, are 2 things. One, which is sort of the obvious one that people talk about, is that a terrorist group or a rogue state or some other enemy of the United States would launch a cyber attack against the United States itself using zombied computers inside the United States. What's not so often thought of is the possibility that that same adversary could, either for purposes of implicating the United States or because they wanted to disguise what they're doing, hijack computers in the United States and actually use them to launch a cyber attack against another nation. And you can imagine, particularly in the wake of some of the things that have happened with the WMD information in Iraq, the president standing in front of the world and saying, well, even though this attack was launched through thousands of computers in the United States, we didn't know about it and we had nothing to do with it. That obviously is a national security problem, just as an attack against us would be. And in both cases, under certain circumstances, the international laws of war, laws of armed conflict would tell you that cyber attack can qualify as an act of war. How did they respond to this concern? Most of you have probably seen the National Cyber Strategy at one time or another. I wouldn't say it's a page turner, and I wouldn't recommend that you wait for the movie, but there are some interesting things in it. This quote is actual United States policy now, as announced in the National Security Strategy by the President. The United States reserves the right to respond in an appropriate manner, and our responses need not be limited to criminal prosecution. That was actually quite little noticed when it came out, but it's very, very important. And for those of you here who are just here for Jennifer's excellent presentation, she talked a lot about the traditional legal ways of looking at cyber attack. And those are civil liability, going into a court and suing someone, or using the criminal prosecution process. And both Jennifer and the previous speaker talked about the difficulties in many cases of making the criminal prosecution process fit activities in cyberspace. What they didn't talk about is what the United States has now announced as its policy, and that is government doesn't believe that its options are limited to criminal prosecution. And what that is sort of diplomatic speak for is using the military or the intelligence communities to respond directly and with force to information attacks that the president or the other leaders determine are threatening our national security. And that is a major shift in policy from what the government had said before. And the corollary point is this one from the national strategy, which all of you know much better than I do, and that is that it's very, very hard to tell, especially in the early stages of what could be a cyber attack, whether this is just malicious activity of a criminal, economic kind, or it's people screwing around, or it's actually something that would really threaten our national security. That's just a photo of the national strategy. It's available on the White House website and the DHS website. It stated a number of things which are important in the context of understanding how the law relates to both national security and information security and individual information security. It laid out the obvious that cyberspace is now essential to our economy, states that all of our critical infrastructure relies on it. Fortunately, I think most people would agree for now, rejects excessive government regulation, although that was almost 3 years ago now, and ChoicePoint and LexisNexis and other events in between have at least pushed the Congress, I think, more in the direction of regulation. And anyone who owns or controls parts of cyberspace are responsible for securing that. And what that translates into is that in addition to the Health Insurance Portability and Accountability Act and Gramm-Leach-Bliley and other federal and state laws that create legal duties to protect, to carry out responsible and reasonable information security, there may actually now be a duty as articulated by the U.S. government to protect your parts of cyberspace. And while that announcement of policy is not legally binding in the sense that you could go into court and be prosecuted for violating it, courts and juries would look at the public awareness of this duty as one element of determining liability. I don't have very many examples here of actual attacks because everyone's been doing a much better job than I could of explaining them. But part of the cause of the National Cyber Strategy was the reaction to the slammer worm. And I'll just point to the middle bullet there. Canada actually canceled an election that they were carrying out because of concern about what the Slammer Sapphire was doing to the online ability to conduct that election. And that event qualifies, I think, under anybody's definition of a national security impact. Now, of course, we don't have online elections in the United States, but I'm sure we will before too long. I don't know if most people know who Richard Clark was. He was, among other things, the cyber czar under the Bush administration. He also, I suppose I should say in the interest of full disclosure, was not only a client of mine, but was Condi Rice's chief attacker in the 9/11 Commission, and I prepared her for that testimony. So Dick and I don't exactly see eye to eye on everything. But I think this is a very interesting point that he raises, that the fact that there was no destructive element to the worm, or at least not a sufficient one in his view, led him to think that this might have been a test of capabilities by people that might want to attach some sort of payload to it later. I took part in a very interesting discussion last night in which one of the things that a number of us here debated was the extent to which the fear of a real, serious, damaging cyber attack against the United States is technologically realistic or not. My view is if you have an adversary or potential adversaries that have the capability, the demonstrated intent, and there are known vulnerabilities, after 9/11 you have to at least take seriously the possibility and prepare for that possibility. But when we get to the question and answer time, I'd be interested in other views. I know there are other views. In fact, one of the authors of a chapter in a book that we'll talk about in a few minutes, co-authored with us, believes that that's not a realistic risk. But I'd like to hear from you guys on that because you are technical experts. I'm not going to go through this example of zombies very much. I'm sure you guys all know this well. I will mention Operation Casper, which was carried out in late 2004 and 2005 by Scotland Yard and the U.S. Secret Service, was an extortion scheme in which a bunch of folks in the UK demonstrated they could take control of computer systems and then decided to, in that case, all they did was threaten the owners of the computer systems that they would use those systems to cause damage or they would damage them themselves to try to extort some money out of them. Fortunately, the U.S. government got onto this early on, and most of the time the attackers were dealing only with government agents undercover. But it was a sort of a wake-up call, I think, for a lot of folks in the Department of Homeland Security and in Washington about how realistic at least this possibility is. And the Associated Press story that ran reported the government saying that there are hundreds of compromised computers typically, and great increase in the past year. And once again, my friend Dick Clark has said publicly he believed in 2004 there were some 30,000 zombie networks in the United States, each with thousands of individual bots. And of course, to state the obvious, which you all know, just because you haven't seen it on your systems doesn't mean it's not happening. One of the breaches from last year was done to the FBI, and the FBI learned about it from AT&T. These are a bunch of examples here. I'll go through them rather quickly because I suspect most people are well aware of them. We raise these to not just to remind people about them, but to try to draw from these principles of what is the evolving legal standard of care for information security. ChoicePoint, obviously 145,000 identities stolen. They've already been sued. Forrest is going to talk a little bit about that later. I think a critical point here, as with a lot of the recent publicly reported cases, which again you all know this well, is this was not in any way, shape, or form a technical attack. So no matter how much information security they'd put into place, it would not have helped them because ChoicePoint believed the people who were getting the information were entitled to get it as customers of ChoicePoint. So one of the things that I think now is part of the legal standard of care for prudent information security professionals to recommend to their clients is you better have some pretty thorough background checking and vetting processes for your customers and make sure that your customers are who they say they are. LexisNexis, this is something that you never want to have to say, and you never want to have your customers have to say, or if you're an information holder, you never want to have to say. This poor guy from LexisNexis had to go and testify under oath that there had actually been a security breach prior to 2003, and we didn't give any notice of that. Interestingly, ChoicePoint and LexisNexis are linked in the sense that the legal damage that I believe is going to come to those two companies is in part caused by not whether or not they should have or could have properly secured the information in the first place, but what they did to react once the attack happened. ChoicePoint, as Forrest will talk more about, sat on the information for a number of months without publicly disclosing it, and of course they're a public company, so there are securities laws implications to that. So LexisNexis turns around, they say, oh my gosh, ChoicePoint is in trouble because they didn't disclose everything. So immediately LexisNexis sends somebody out to describe the situation and say that 32,000 people were compromised. Well, the last time I looked, it was already up to 310,000. So LexisNexis, reacting to what ChoicePoint did, made the opposite mistake. And point here is you need, obviously, to have a crisis communications plan. It needs to be well and carefully thought out, and you need to have designated folks, in our judgment, advised by attorneys who are speaking for the company and who are careful what they say on both sides. You obviously have to comply with the disclosure laws, like in California, for example, and I think there will be a federal law analogous to the California law requiring disclosure of breaches soon. But you also got to be careful what you say. This is Time Warner. Iron Mountain is the other firm that lost information on 600,000 current and former Time Warner workers. Secret Service is still investigating that incident. But again, one of the things that people probably didn't pay enough attention to, and I don't know any inside information about the facts of the case, but is not only what your information security practices are, but making sure that when you contract with others to have access to your data, that they have procedures that are at least equivalent to yours, and you have some way to enforce that. Number of banking cases, obviously, in the last few months. I'm sorry to say that one of the major customers for the stolen Wachovia information was lawyers. And I think this illustrates the point that, again, much like ChoicePoint, this was not in any way, shape, or form a technical attack. This was a matter of policies and enforcement of policies with regard to their own employees. Citigroup, I believe, at least as of the last time I checked, this is probably the largest hit so far. And again, this was not a this was a case of control and the ability to control information when it gets into the hands of third parties. Someone asked me earlier before the presentation about the Cisco related hack. I don't know a lot of the technical details about it, but what I do know is that this was definitely a hack. This was a technical theft. It was not any sort of policy or procedural breach, and the information was very significantly used to compromise thousands of computers, including in the U.S. government. So this illustrates, again, something that's probably obvious to most people here, that very, very big, rich, and sophisticated institutions can sometimes be victims to information security attacks as well. It took many, many months to unravel it. Turned out, at least the last time I looked, that they believed that it was a Swedish teenager responsible, and it was almost entirely launched through university servers, both in Europe and in the United States. We'll talk a little bit more about universities. I don't know if there's anybody here from colleges or universities. A number of our clients are colleges and universities, and as you know, they're very much preferred targets. Highly networked, lots of computing power. Many of them have classified and unclassified U.S. government information for research grants. And the government, and we dealt with this a lot in the White House and in the Justice Department, is very reluctant, for good reasons, to intrude upon the academic freedom and the privacy of universities. And in my view, the terrorists or others who have bad intent towards the United States understand that. They use university servers because they know it's very, very hard for the government to get behind that first hop to the university server. And I don't think it's any coincidence that the Solar Sunrise intrusion came from a university, although I'm making no comment about Harvard in that. A bunch more university stories. I'm not going to spend too much time on them. This is one of my favorites. Of course, Carnegie Mellon University runs the U.S. CERT program that I'm sure most of you know is intended to find out and publicize information security vulnerabilities. And within the last 6 weeks, 2 months, I guess now, 3 months, they got hacked. And they said publicly they have no clear idea how long their systems were vulnerable. I don't know this, but I suspect somebody lost their job over that. What are the sources of liability? What are the legal regimes that apply to information security? For those of you who sat through Jennifer's presentation just before this one, she went through these in some detail. And most of you probably are aware of them. Healthcare, personally identifiable patient information, and other healthcare information is regulated by the Health Insurance Portability and Accountability Act. HIPAA, Gramm-Leach-Bliley does similar regulation, although not as detailed for financial information, and there are other statutes as well. One of the things that a lot of people don't think of in this area is state law. Every state in the country has deceptive trade practices statutes, so you're not allowed to commit false advertising. Couple of very well-known now pieces of civil litigation were brought against Microsoft and against Ziff Davis Publishing, which publishes, as you probably know, computer magazines. Those guys were not regulated by HIPAA. They were probably not regulated by Gramm-Leach-Bliley or any other federal statute or any other computer crime law in any state. So the prosecutors in both cases said to them, listen, we went on your website, and you have statements that you will keep your customers' information secure. You didn't take reasonable measures to keep your customers' information secure. So the fact that you said you did on your website was deceptive advertising. Now, as a lawyer, had I been defending against that case, I think I could have made some pretty good arguments that that wasn't a valid reason for prosecution, but obviously Microsoft and Ziff Davis thought it was, because they signed consent decrees that very specifically regulate, even though they're not subject to HIPAA, even though they're not subject to Gramm-Leach-Bliley, their information security practices, and those decrees are for 20 years. So their lawyers obviously convinced them that it was worth having the government crawling inside their company to monitor that decree for 20 years in order to get them to sign that. Those decrees are probably excuse me, are available on the internet, and they probably include some of the best information to tell information security professionals and organizations that have sensitive information what the current state of play is on the legal standard of care. One of the things they specifically require is, which I think will be near and dear to the hearts of most information security providers here, frequent outside third-party neutral assessments of the information security posture. So it's obviously not enough to have the greatest professionals inside and even perfect security inside. They are now legally required to have outside independent assessments. The consent, that's a good question. The question was what size firm. These two consent decrees or settlement agreements only cover Microsoft and Ziff Davis, the two companies that signed them. Pretty large firms, obviously. What this does, though, when you have a statute like HIPAA or you have a regulation or you have this consent decree that's publicly available, juries and judges and regulators in the future would say, well, even though you weren't Microsoft, even though you weren't covered by HIPAA, these practices are now out there, and you had a reason to know that they are what was required by law as the standard of care. So you were responsible. That was your duty to satisfy that standard of care, regardless of the size of the company. Now, having said that, what you're expected to do is not have perfect security. What you're expected to do is have reasonable security. And say again?
To do your due diligence.
To do your duty.
Diligence.
Due diligence, that's right. Although due diligence is normally, when lawyers talk about due diligence, they talk about it in the situation of finding out information and understanding what information's out there as opposed to actual security practices. But that is the concept. You have to do what the reasonable standard of care is at a particular time. And we'll talk a little bit more about this in a minute. But the problem with that, of course, is that what's reasonable changes every day. 6 months ago, it might not have been reasonable to have a contract with a third-party storage company that you can enforce to protect security, but I can assure you that it's going to be considered by the law reasonable now after what happened with Iron Mountain and Time Warner. And of course, the federal government also will help us out in this area, I think, even more than they already have, because there are at least 6 bills moving through the United States Congress right now in response to a lot of the recent publicly disclosed breaches, the weakest of which matches California's Senate Bill 1386, which says if you do not encrypt data and there's a security breach, you must then you notify the public that there was this security breach. That, I predict, will it'd be the minimum that the federal government does, and there are lots of more detailed, tougher standards in laws that are moving through the Congress right now. And it's very possible that despite the administration's wishes, there is going to be more federal statutory regulation that goes beyond just the healthcare community and the financial community under the specific statutes of HIPAA and Gramm-Leach-Bliley. Where else do you incur legal obligations that could result in liability? Obviously, contracts. Many contracts that information service providers or information owners sign with third parties require specific types of security measures, or at least reasonable security measures. As I mentioned earlier, statements on the company's website under the Deceptive Trade Practices laws are one of the most, I think, ingenious things that prosecutors have done in a while. Obviously, then, when and if something happens and there's a breach, you will be sued potentially by victims, maybe by employees if their information was compromised. And then, of course, for publicly traded companies, you get into this whole other level of litigation, which Forrest will talk about, where people that buy the stock believed they were buying stock in a company that kept information secure. The company knew they weren't secure and didn't disclose that, so those people, in effect, are going to say they were defrauded. They wouldn't have paid that price for the stock. Similarly, if other obligations exist to have reasonable security practices and a company doesn't, the shareholders are going to, and there's damage to the company, the shareholders are going to say the value of my stock went down, therefore you need to pay me. Sarbanes-Oxley, also I think a big, obviously, boom to the information security provider community. actually got the attention of big corporations because it creates individual financial liability, very serious financial liability, for senior management of a firm that does not have sufficient internal controls over financial information. Now, it's done a little bit indirectly. Sarbanes-Oxley doesn't say you must have good information security, but what the regulators are saying about it is you're responsible, Mr. CEO or CFO, for signing documents that state the accurate financial situation of your company. And if you can't demonstrate that you had controls in place to make sure that information was accurate, which would include secure, then you can be liable. Now, I don't think we've seen any actual regulatory cases of this yet, but I believe they're coming. And then I'm just going to touch briefly on the international facet of this. Obviously, the most, I think, well-known international law dealing with information security is the EU Privacy Directive, which covers not only activities that happen in the countries of the European Union, but also really anywhere in the world that data of a certain type, personally identifiable data of EU citizens, is compromised. Now, there's a whole separate issue of whether if you're sitting in Iowa or in Colorado or in Las Vegas, the Europeans could ever get their hands on you to have a lawsuit against you. But the law is out there, and it's quite stunning. This directive does require companies to, quote, guarantee the security of networks and services. And obviously, we all know that you can't possibly make such a guarantee, but that's what is required by the European Union. Other reasons for information security providers and companies that hire them to care about this, as if operational damage and economic loss and potential counterattacks by the government and lawsuits weren't enough. Government is going to regulate, and they're going to regulate more deeply to the extent that the private sector doesn't get our act together first, which is part of the reasons why we're in this business, to try to help people get this right so the government doesn't do it for us. Obviously, negative publicity and positive image of companies that have good information security and can demonstrate that. All right, so, yes, sir.
Just a quick question, if you share my opinion. It seems to me that a lot of the information security problems we're seeing today, I believe, are going to be perceived as a risk to public safety eventually by the federal government, I mean, in a very formal way, and will be viewed, I think, akin to public safety issues and also environmental protections, where I think regulation is inevitable, in part because companies avoid costs, because it's a competitive issue. And I think there's going to have to be level playing field in order for companies to do what's right, because then their concern about costs will be abated. What do you think?
I agree with you that more regulation than we have now is inevitable. I think as long as this administration's in power, their view is to continue to try to help the market find ways to regulate themselves. And a lot of the theory of the people in Washington right now would be, well, the economic incentive in the market is there because companies that are viewed as having good information security will pull business away from companies that are viewed as not having such good information security. Having said that, politicians in the Congress and in the administration and in every state respond to current events. That's what they do. And so every time you have a ChoicePoint or a LexisNexis or these university incidents, that then makes the politicians say, well, what can I do, partly out of good motives and partly out of, it's a hot issue and they want to be on the bandwagon. I do think that it's unlikely in President Bush's term that you're going to have extremely specific and detailed regulatory requirements because of their philosophy, number one. But number two, even a lot of the folks in Congress who want to regulate in this area believe that it is just too complicated and too ever-changing for the U.S. government to actually get it right. So what's more likely to happen than detailed regulation, you must have this firewall, you must have this personnel policy, I think is going to be disclosure laws and laws that say you have to have reasonable security in the following areas, like administrative, physical, technical. So we'll see. Sir?
How about, say, in the utilities, like, electric power industry is considered the most critical infrastructure. And NERC has recently come out with a set of cybersecurity standards that the industry said, we don't want to implement these. So FERC turned around and said, okay, NERC has to make them voluntary, which means that nobody is going to do anything about cybersecurity in the electric utility industry. Same thing in the chemical industry, etc. I mean, you have areas in which there's no competition, like utility. You can't have people going to another utility, electric utility, but no one wants to do anything about security. And same thing, NRC won't even force cybersecurity on the nuclear power plants.
It's a very good point. I think the most likely federal regulation will come in areas, obviously, where folks conclude that the biggest threat is, and where elected officials conclude there's a realistic possibility of a catastrophic attack, which is why I sort of teed up that question earlier. I also think it's obvious that the bigger and more wealthy and more powerful an institution is, like the electric industry, like the nuclear industry, the more they're going to be able to help dilute any regulations that come or block the enforcement of such regulations. But I promise you that regardless of who's sitting in the White House and in the Congress, if there is a catastrophic, either economic or worse, attack that's using cyber, then whatever that industry is going to get hit and hit hard and should. In the meantime, I hope the lawyers for a lot of these industries and individual companies are saying to them, you're idiots to wait for Washington to do this, because you may not ever get regulated by the government, but you're going to get sued out of business by the victims of an attack. So I'm hopeful but skeptical at the same time. Sir?
Brian, can you talk a little bit about the impact of the failure of plaintiff attorneys to show cohesive cause of action and economic damages in these cases, civil cases, and the feeling among organizations that maybe don't do information security so well that there's really no tangible economic cost?
Well, I think they're going to learn that lesson from ChoicePoint. Forrest is going to talk about that lawsuit. I think ChoicePoint is extremely vulnerable. I don't know anything about, I don't represent them. I don't represent the plaintiffs. I don't know the internal facts of the case. But it really is only going to take, just like in the healthcare industry and just like in environmental cases, it really will take, unfortunately, some big institution to get hit hard by damages for people to wake up. And I think you're right that right now there's a lot of factors that are preventing a lot of corporations from doing more in information security. One is that what you're talking about, that nobody really has been hit hard yet. And so they figure, well, to be cynical about it, they figure, well, it's a cost of doing business. Even if we get hit at some point, it'll be cheaper than taking the measures between now and then. The other one is that I think a lot of information security consultants and lawyers, to the extent there are any lawyers practicing in this area, haven't figured out how to persuade corporate management that there's a business case to be made for information security, that it's not just avoiding legal liability. There are lots of compelling business reasons to do it. And I think we're getting more successful at doing that. I don't believe, to directly answer your question, that we're going to go very much longer without a major success by the plaintiffs' lawyers. I don't know if I think it may well be ChoicePoint. I don't know. It could be LexisNexis, could be DSW Shoes. Somebody's going to get hit hard, and I think then you're going to see a lot of people wake up.
Follow up. I thought TriWest was going to be that case, which is sort of similar to what happened with Twitter. And when it went to court, the judge said, regardless of whether there was any negligence on the part of TriWest in taking the data, I just don't see any damages here. And it seems to me that that's going to be the case.
Yeah, I mean, except under certain statutes, you really will never get, unless you have damages, it doesn't matter how bad the negligence was. My point is, you're going to see a case soon where there are major damages. Forrest, did you want to? You're reaching for your button. I don't know if you want to.
Well, I'll chime in a little bit. We'll get ahead. I think that the problem is that the plaintiff's bar is very creative, and there's no end to the theories that they can concoct. But the facts also drive the case. So, for example, in ChoicePoint, one of the class action lawsuits in Georgia relates to the fact, as Brian alluded to earlier, that management didn't respond appropriately, right? So first they came out and they understated the number of clients who were exposed to risk. Left that alone, several months later updated it, and now all of a sudden you have this gap period with individuals who are buying stock based upon misinformation, securities violation under 10b-5, and it becomes expensive. There can be treble damages, et cetera. So the facts are going to drive the case. There's no panacea, and that's why negligence is always part of the plaintiff's bar. You have a duty, you breach it, it causes damages. Approximately, you've got a case. And so I think part of what I'll get into a little bit is how companies can try and anticipate what will be the standard of care to head off those types of claims as best as possible.
Do you guys see the possibility that, like with the asbestos cases where they were plaintiffs very successful, showing that if someone was just fearful that they may get asbestosis, they still had a cause of action, and there was an economic value associated with it? You see that happening with the threat that maybe your
Yeah.
asset is going to get stolen, and that has some value.
My view is that's going to be very tough because, for one thing, the people who would be judges, whether they're supposed to be or not, in many cases are economists, self-appointed economists. And one of the things they say to themselves is, what will be the consequences to the whole society if I rule a certain way? And the problem with that theory is every single one of the 280 million people in America could make that claim. A little bit different than asbestosis because I think, although I don't litigate those cases, I think the people who have successfully had this fear of injury, fear of illness claims, are people that actually have been exposed to the asbestos and have a reasonable reason to believe. Now, what I think would be an interesting variation on that, though, is all of the people who were notified, not to pick on DSW, but on DSW shoes or these other companies, that their identity information has been compromised, and so they know their identity has been compromised, but nothing's happened yet. Let Forrest weigh on this. I suspect even then most courts are going to say, no, come back when you have some damages.
Yeah.
Including the chairman of the FTC.
Right. Well, and again, when you're talking about negligence is an easy category to identify, but there are many other claims. They are going to look at, was there something that proximately caused damages, and if it's speculative, courts generally say the damages which are speculative or not causally related to the claimed injury are not awarded. And so I think that's going to be at least a premise in the law that's going to preempt a lot of those types of claims.
Is there a question here?
Yeah, we have another case which is not actually related to identity, but the car system issue, okay, when they were storing information about credit card transactions, okay, information got stolen, and Visa, MasterCard say, okay, they have policies, they didn't follow the policies that we have stated, and then car system says, yeah, but we passed an external audit, okay? Those guys came and told us that we were secure. Now, I'm not really focused on what's going to happen to car system, probably it's going to fall, okay? But what's going to happen to those guys who performed the security assessment?
Yes, that is a question to which we give a great deal of thought, and so do our malpractice insurance carriers. Look, one of the reasons you'll see in a few minutes that one of our recommendations and what we actually do ourselves is to rely on a well-articulated, publicly accepted methodology. So we use the NSA IAM process on the theory that if we ever get, our clients, or we ever get hauled into court, if we follow that methodology correctly, the argument is, listen, this was the methodology that was designed by the United States government to protect the most sensitive classified information we have. We also did our own due diligence to compare that against the other standards that are out there and try to pick the best methodologies, number one. Number two, we followed it, the methodology, which I would argue in your example, the service provider is going to have a hard time making that claim because the first thing they should have done is got their hands on the contracts that the smaller companies signed with MasterCard. And you could never advise somebody responsibly that they might have met all the best practices in the world, but they can go ahead and ignore contractual agreements that they made, which is one of the reasons why one of our pitches is to have lawyers involved in this process. So I think if the information security provider can show that you followed an accepted methodology, that you kept current on what the threats were and what the litigation risks were and what the standard of care was, and something still went wrong, the question for them by a jury or a prosecutor or a regulator is going to be the same as it is for the original company, which is, did you do what was reasonable? So it doesn't mean, were you perfect? It doesn't mean, did you make no mistakes at all? It doesn't mean, did you overlook, one of 50 firewalls? It means, were you acting reasonably? And that comes down, in a lot of ways, to the same thing that applies to the companies that you're assessing. Do you train your people well? Can you prove you trained them well? Do you train them on a good methodology? Do you test them? Do you evaluate them? Do you let people go that aren't living up to your standards? Can you be immunized from being sued? No, because lawyers can sue you for whatever they want. Are you going to have a good chance to win that lawsuit if you follow the things I'm talking about? I think you will. So now that I've reminded everybody, I'm sure. Oh, sorry. Yes, sir.
One thing I want to point out is you did mention 10B-5. When the company disclosed that they thought that 32,000 accounts had been compromised, and then later disclosed that they believe it's actually a much greater number of accounts, if any of those 32,000 accounts had been notified directly under 10B-5, they would have had to make that disclosure to the public as well, because if any of those 32,000 individuals had been a shareholder, that could be considered material non-public information, at which point it does have to be disclosed to the public. So if there's, when it made the statement that there was 32,000 accounts compromised, if they also stated we're continuing to do our research or do our discovery on what happened there, that lets them notify those initial group of people, comply with the 10B-5, as well as continue the research and gather more information. If they said that only 32,000 were compromised, then there's a difference.
Well, to the extent that's a question, or a statement either one, I agree with you. And I think one of the things that, since we're kind of doing a little open forum, that I was going to address is, as a corporation that maintains sensitive information that needs to be secured, and most companies have some level of criticality of their information, when this information gets into an area, if it's compromised, it can affect stockholders, whatever it may be. What is part of the protections that are important to a corporation are to have into place a glide path, a plan to say, what do we do when the crisis occurs? And have management trained on just the types of things you're talking about, where we don't come out and try and minimize or mitigate the appearance of this, but address it specifically. And I think that's what you're suggesting. And there's no opportunities that I'm aware of for prosecution or civil liability in the law based upon the truth. And what you're suggesting is, if the truth comes out and you say, shareholders, we have a situation, or prospective purchasers, here's the extent of it that we've uncovered based upon our best information to date. We're continuing to investigate. That may be modified up or down, and you continue to make those disclosures. That is a part of perhaps a plan that should be implemented through working with counsel and working with teams like this that says, this is how we avoid liability when a problem occurs. So your point's a good one, and you're exactly right. It's when people get nervous and stop short because they're not sure how to react, that they either really did wrong or they gave an opportunity to the plaintiff's bar to try and prove they did wrong.
The other facet of this from an operational standpoint, is, in addition to a legal one, is having a plan in place and having the management of the company and the employees understand that there's a plan in place for crisis management and crisis communication is a huge operational benefit. Because what it does, in addition to helping you legally, is it then allows the rest of the company to go do something that resembles the work they're supposed to be doing, as opposed to everybody being like kids running for the soccer ball and everybody thinking they need to be involved in managing the crisis. There were, as you could imagine, a lot of things I think the Clinton administration did wrong. One of the things they did very right, and I think it's amazing that they were able to do this, was to run the country during the impeachment process. Because the overwhelming tendency is for everybody in the White House to want to be, to be worried about the impeachment and be fighting that. And I asked their Deputy National Security Advisor how they did it. And he said, well, we had, 5 people whose entire job was to manage that crisis. And then the rest of the people knew that there was people full-time doing that and that was their role. And so the rest of the people could go about and do their business. I think that's very important for any kind of serious major institution, to make sure you know who's going to be dealing with the crisis, who's going to be talking about it, and who's not, so that you don't have 5 people saying different things publicly, and so that the company can go ahead and function while you're managing the crisis. Sure.
One point with what you said. I think that you're between a rock and a hard place, because if you don't have a law that actually forces you to disclose what happened, if you prefer to go public and notify the 32,000 customers, you're in a tight spot, because if you don't notify them, customers are going to they're going to come after us. But if you do notify them, the information is going out. Probably the company value is going to go down, and the stockholders are going to come after you. So you actually need the law, you need the government to pass law to cover your back.
Yeah, that's going to happen. I mean, I would bet a year's pay, which is not that much, but I'd bet a lot of money that that there will be this year a federal law that says you must publicly disclose information security breaches. I just don't see anybody. There are two moving through Congress right now. I don't see anybody standing up meaningfully against it. I mean, industry will lobby against it, but politically, I think it'll happen.
And your point is, you are correct. I mean, they do place you on the horns of a dilemma in some sense. And so the issue is not if a company, or some company is going to be placed in that position. It's a question of how do you get out of it and mitigate the liability as best you can. There's information that goes through society all the time, through public disclosures and your securities filings, through the media reporting, that constantly affects share prices for publicly traded companies. Whether it's breaches of security or embezzlement by the CEO, whatever the examples, that's part of society. I mean, that's part of the free marketplace of information. States, I believe beginning with California, have already passed mandatory disclosure laws. And that's part of a response, saying we want that information out there. So again, part of a plan that addresses how a company responds in the face of these sort of breaches may not save the share price from falling, but it may stop how far it falls. And I think that's the key to it. It may save the management. It may save the existing shareholders.
Well, it might save the company.
It might save the company. It might allow it to rebound as well. Yeah.
Right. So some of the stuff I'm about to talk about is going to be very elementary to this audience. We talk a lot to folks that are in corporations and institutions that are just trying to assess whether or not the problem is just too big. Information security can never be really fixed. It's too hard. It's going to cost too much money. We don't have budget this year. And so some of the advice that we give folks is don't let the fact that this is kind of overwhelming paralyze you. You have to start somewhere, and you will get a lot of credit by prosecutors, which I used to be, regulators and juries, for having a reasonable plan for how you're going to assess over a period of time and remediate your security issues. If you have the plan in place, and it's a reasonable plan and you're following it, and say it's got 20 items on it, the fact that when you're on item 4, the bad thing that happens would have been addressed by item 18, obviously it'd be better legally if you'd been done, bless you. But you're going to get a lot of credit for having a good plan in place and executing against it, even if you haven't gotten to the right fix yet. Obviously, I think few people in this room would disagree with me that it's critical to have outside, neutral, third-party advice. As I said earlier, that's now starting to actually be memorialized in the law, but it has to be good advice, obviously. And you all know this. The two of the keys to good information security, I think from a best practices technical standpoint, but I can tell you for sure from a legal standpoint, is you have to cover comprehensively both the technical and the physical and the soft policy, personnel, administrative compliance measures, which have actually, the failure of those have resulted so far in a lot more serious breaches, I think, than the technical. This is the national security strategy, cybersecurity strategy again. Again, by public statement by the administration, reinforcing and enhancing this legal duty that we have to do what is reasonable by pointing out as a matter of policy the obvious, that you can't just put a static policy in place. It has to be ongoing. Again, I think good news for information security consultants that you can constantly have to be reassessing and reevaluating. And that's more than just a legal point. There's also the obvious one that the offense will always be able to stay ahead of the defense, and so you have to continually evolve your processes. I remember in the first Iraq War that Saddam Hussein, while he generously gave us 9 months to let us build up our troops in Saudi Arabia, also would come on TV all the time with new threats about how badly he was going to be able to destroy the American army. He dug a huge trench between Kuwait and Iraq, and then he filled it with, he was going to fill it with boiling oil and tank traps and explosives, and he actually did all this stuff. And then, of course, the U.S. Army came and dropped bridges over the trenches and rolled right into Iraq. So offense often can overwhelm defense if you don't keep updating your plans. Standard of care, as we've talked about, is being established in the law. The good news here is actually not too squishy. I mean, there's an awful lot out there that tells you the kind of measures that ought to be put into place. As I mentioned, the circumstances keep changing. We've talked a lot about this, so I'm not going to go into it much at this point, but these are where the standards of care come from. This is where you're told by the law you should be aware of what's reasonable. Obviously, external independent standards are good, as I mentioned earlier. Reasonability. Forrest has already talked about this. Absent a federal or a state statute law passed by the legislature, there still are common law duties. You must perform reasonable measures to protect against foreseeable internal and external risks, but the law is very flexible in this area in terms of determining what was reasonable. As I said, you don't have to be perfect. What will be taken into account, somebody asked earlier about whether the regulations and the consent decrees apply equally to different sized companies, and the answer to that is no. It does matter how big you are, how much money you have, what you can afford to do, and the law will do a balance, and they'll say what was reasonable based on the size of your company and the threats that you faced. I'm going to skip through a lot of this because you guys, I think, probably know a lot of that. The complete solution, obviously, I think most people would agree, not only technical solutions, but also addressing physical security, policy, legal issues, becoming very important now, as I said, in the law, independent outside evaluation. We've talked a lot about already incident response. And another important, I think, skill set that's becoming critical for at least significant size institutions to have is the ability to deal with law enforcement, Homeland Security, and intelligence when they do come calling if there's a breach that involves your company. I said earlier that you're not required to do everything at once. Budget concerns are valid in terms of figuring out what your information security planning is going to be. One shortcut that I would strongly recommend you advise your customers not to take, and I'm sure many, many people in this room have been faced with this, is they'll say, well, I only have X amount of dollars, so why don't we start by a penetration test? You come in, you try to beat us, you show us what you learned. Sometimes that's for budget reasons, sometimes it's for internal political reasons. The security officer wants to prove to the board that he needs more money. The IT people want to prove that the security officer doesn't know what he's doing. It's a terrible idea. Because what happens is, I know a number of people in this room, and they will beat the customer almost every time. So now what you have is you've started in the middle, you haven't assessed the criticality of the information you have, you haven't understood what legal requirements apply, you haven't tried to fix the vulnerabilities that you can fix before you launch the test. So you're going to fail it badly, and critically from our standpoint as lawyers, if that assessment, if that penetration test has not been conducted through a law firm hiring the technical consultants, there's no protection for that information. So now you're going to have a report that shows how badly you failed. That's going to be completely vulnerable to litigation, to prosecutors in the future. And for the information security providers that do the test, you've now become a witness, because that report's going to be sitting there. It's going to document what you found, and we'll talk a little bit more about this in a minute, but in some cases you're going to have to go and testify and reveal all the methods that you used to find that information. Why do I bring that point up? This is not just a shameless commercial for us. It would apply to any information security lawyers, Jennifer and others. The attorney-client privilege protection over the results of information security assessments, I believe, is absolutely critical, at least to make sure that your customers consider. I show that the confidential national security stamp, which could have easily said secret or top secret, except I couldn't find one on the internet, versus the attorney-client privilege. I was a litigator for the CIA for a number of years, and I will tell you, it is harder in many cases to get a federal judge or a state judge to overturn the attorney-client privilege and force information that was developed through a law firm to be released than it is to get classified information declassified. Okay. So, shameless commercial, why have a law firm involved? Reduces the litigation risk for the customer. I just mentioned the attorney-client privilege. If Company X hires our law firm or another law firm to advise them on their level of compliance with HIPAA or another federal statute, and we then hire technical consultants to give us the factual information that we need, the report of the technical consultants through us to the client is going to be protected in litigation. Not a silver bullet, no absolute, but much better than not having that. Top 10 reasons to have a law firm involved. Number one, you cannot practice law without a license. I don't know if there are any consultants in here that purport to advise their customers on their compliance with HIPAA or Gramm-Leach-Bliley or another federal law, but if you're doing that, you're probably breaking the law. Because every state in the country has rules in law that say only lawyers acting in a law firm can advise people about compliance with the law. Can't lawfully advise on those. Does not provide attorney-client privilege protection. Doesn't offer an advice of counsel defense. In civil litigation, particularly, it's some degree in criminal, but it's less powerful. If you come to a lawyer and you fully and accurately lay out a set of facts and you say, please advise me on what I need to do, and you follow that advice, that can be a defense to litigation. Not if you're getting advice from non-lawyers. Helps to reduce the liability potentially of the information security provider, someone else to blame if you're not current on things. We can help you write contracts that will make you as bulletproof as possible in terms of liability between you and your customer if something goes wrong, to fight with the other guy's lawyer. And, of course, the most important reason is you don't want to be this guy. And I will thank my friend Travis Shakir for pointing me to this. Judge Lamberth, federal district judge in the District of Columbia, is running a long-standing feud with the Bureau of Indian Affairs, and one of the elements of it is information security. And this was an unfortunate information security provider who spent 9.5 days testifying in public under oath about the methods that he used to perform information security assessments for the Bureau of Indian Affairs. And I promise you he was not happy about it. Already talked about that. How do you pick lawyers? Are they well regarded in the professional community? There's websites and other sources you can find that. Can they prove they've got expertise in information security law? Are they published in this area? Like, for example, this book right here, Network Security Evaluations by Singris, which Forrest and I are the authors of the legal chapter. It's available at the bookstore across the hall. Are they trained and certified, for example, in the NSA methodology? You'll find that we are. And I've cheated Forrest out of most of his time, but I'll turn it over to him for the rest. Thanks. Sir. Right. No. And this is, obviously courts are skeptical in a lot of areas. This has never been litigated in the information security cases yet, but it has in environmental and other cases. Courts are very skeptical that companies will get a lawyer involved for no other reason than to create this privilege, that really all they want is the technical information, and they'll essentially launder it through lawyers. The way it has to work is the client has to hire the law firm to advise them on a legal issue, like compliance with HIPAA or like compliance with Gramm-Leach-Bliley. But obviously lawyers, most of us, don't know anything significant about technical issues, and we have to have technical experts to advise us so we can then tell the client whether or not what the technical experts found amounts to appropriate compliance under HIPAA. So in order to have the protection, it has to happen that the customer or the client hires the law firm, which then hires the technical advisors. It will not work the other way. It's also not retroactive. So in my earlier example, if the customer went out and got the penetration test and failed it and had this report that they didn't want disclosed, they could not then go out and hire attorneys and give them the report. Once it's done, it's done. You have to do it from the beginning. Sir?
Is it true also that even in that relationship, all the work products should be labeled attorney-client privilege?
Absolutely. That's not dispositive, but it's an important factor. Sir?
What about in-house corporate counsel?
It does work to some extent, but there is a distinction, and that is that Brian can talk to it as well, but the problem with in-house counsel becomes twofold. One is you lose that independent third-party assessment for objectivity. Secondly, the attorney-client privilege is a little bit difficult to define with in-house counsel for the reason that you have to ask the question, are they performing legal services in advising their client, or are they acting as a manager? Those issues do not come up when you deal with outside law firms, and it's sort of presumptively assumed, that the line is a lot broader when you're dealing with outside counsel that the privilege applies.
Yeah, I agree with that. Let me just add, it's better to have the outside technical consultants hired through the in-house counsel than not to do that. But the protection by using an outside law firm in many, many states has been found to be more powerful because, as I said, courts generally are skeptical about corporations trying to have this privilege. And because in-house counsel wears so many different hats, and a lot of what they do is business advice, courts make it much harder to prove that the information is actually privileged. Sir?
If you get back to the assessment part, if you do an assessment for client and you turn over the data, and it's their information to protect and do whatever they want with after that fact. So why do from the consultant, what other things are you getting from that going to the lawyer?
I think there's the two principal things are, number one, well, I guess three things. Number one, it gives, in our view, obviously prejudice, and it depends on who the lawyers are, but it gives the customer a better product because it's better able to be protected in court, and because most lawyers that are practicing in this area that are good lawyers have skill sets that are helpful to producing information that if you did wind up having to go to court and either you lost a fight over the attorney-client privilege or you, the customer, wanted to use the information to prove you did the right thing, like this gentleman over here's example of showing that they complied with the external assessment. Lawyers know how judges and juries think, so we'll write reports and we'll edit reports in a way that they'll be more persuasive and more admissible in court later if they have to be used. The other point, I guess two other points for the information security provider is lawyers are able to help you do your job in a way that is going to better insulate you from liability to your customer if something goes wrong, and also protects you from being a witness in future litigation, because if the subject matter of your report is privileged and the court upholds that, then you can't be called as a witness to explain how you got to your results. Now, you may not care about that. I mean, some people don't, but a lot of people either just don't like to testify or they don't want all their trade secrets of how they do their job to be revealed publicly.
Sir? Does attorney-client privilege protect government entities and disclosure under FOI?
Yes, but there is a specific Freedom of Information Act exception, or at least the courts have concluded that within one of the other exceptions there is. Obviously, that privilege can be waived by the government, like President Bush is doing now with a lot of Judge Roberts' material. Also, attorney-client privilege can be lost by careless handling of the information. So, in your example, if I would have advised Condi Rice about something, that would be protected from disclosure because it's attorney-client privilege, among other things. It would probably classify and other things. But if there was a reporter in the room when I said it, or there was some outside third party who isn't protected by the privilege, it's waived. The law says even though your lawyer was telling you something, you didn't take any precautions to prevent an outside party from knowing, so you waived it. Sir.
Gentlemen.
Yeah, quick question. Instead of using both an outside law firm and an outside IT security consultant, let's say I, as a CEO of an entity, come to you, an outside litigation firm, law firm, and you then direct me, because I'm asking for advice, that my own internal IT staff conduct a significant IT security assessment based upon the fact that you're advising me how to meet HIPAA or how to meet Sarbanes-Oxley, whatever the case may be. Would that information, even though it was generated by an in-house IT security assessment staff, be protected under that attorney-client privilege?
Well, I guess I'd say two things about that, and Forrest may want to weigh in too. The first one is if the outside lawyer is hired to provide legal advice, the fact that it's in-house people that are providing him with the technical information, or her, is not going to destroy the privilege. But what you're going to lose, for sure, is the benefit of being able to say, that under HIPAA regulations or under these consent decrees, you had outside independent third-party experts.
It's also
on the technical
generally,
side.
it's generally been recognized by the courts too that when you're dealing with the attorney-client privilege, it can't be a sham. It has to be real. So that you have a situation where attorneys hire environmental consultants or IT consultants or whomever they may be, it's to assist the lawyer in developing their advice to the client. So just to have a lawyer come in and say, I'm going to throw a shroud of privilege over your IT department generally doesn't work. I mean, that's usually pierced, and the effort to accomplish that result is generally discovered.
I'm just thinking of the larger business institutions that have multiple organizations within that business institution that, you know, could probably or most likely, you know, handle that particular technique.
And then, as I said, the issue then becomes, can the internal staff, no matter how competent they are, ever be said to be neutral and objective? Even if they're trying to be, because they're too close to it and there's all kinds of internal political and other issues that come into play. So that's not an attorney-client privilege issue, but I guess we would still recommend against that, even though I guess it'd be financially beneficial to us, because of this losing the neutrality and objectivity. Now, for any kind of investigation, I mean, lawyers obviously get hired all the time to come in and conduct internal investigations which have nothing to do with information security. If there's a theft inside the company, if I get called in or Forrest gets called in to conduct that kind of investigation, the information that's provided by the employees to us, and then we turn around and report back to the board, that's still going to be privileged. Forrest's point, though, is the right one, and that is you have to be able to demonstrate you had the right motives. It can't just be done as a way to protect the information. There has to be a real legal service that you're asking to be done.
Let me tie a couple concepts together too, because you guys are not going to get the privilege of the majority of my talk, but that's all right. But one of the things that I wanted to address is how, we're talking about all of these, what I call FUD factors, right? The fear, uncertainty, and doubt. We can't define the law. We don't know what the outcome, how our juries are going to handle this. One of the things that does become important is when you're challenged on a corporate level for your conduct, no matter how well it was done and how properly it was evaluated, there's a sense of less acceptance, if you will, by a judge or by a jury typically. When you come in and say, look, we've got the best IT department in the world and our gurus have sanctioned this and said it's correct. Now that might be true, but you got to know that somebody who's looking at that knows the source of the information and is going to raise a little bit of an eyebrow at that. If you say alternatively that plus, we went one step further and we hired some people on the outside who were IT professionals such as yourself, and we were advised by a law firm who has some expertise in both corporate matters and information security matters as to what laws applied to us, what policies we should implement, and we've done that and we followed it. You could sit there yourselves, pretend you're on the jury. Are you a little more influenced by the fact that there wasn't the fox guarding the henhouse effect, but now there's the effect of, gee, these folks went one step further and they had it independently verified. Does that now suggest to you you've met a certain duty of care? Does that say to you, as a juror, you're trying to figure out what the standard of care is, and you have a guy like Brian come in, or other attorneys like Jennifer who spoke and said, look, this is what we think is appropriate, and we all recognize that there is one perfect answer to security, right? You turn off the computers. But that totally destroys business. So somewhere in that sliding scale, you have to get work done and you have to make a profit. And when that happens, and you've had somebody say in that context and allowing the business to operate, that's a level of care, then again, it's minimizing the liability. It may not keep you out of court, but you might like it better when you leave. And I think that's part of the third-party assessment concept. I don't know what time it is, about 6 o'clock now. My two topics, for what they're worth, and everybody's free to leave when you want. I know the casino misses me since I was able to fund them last night quite a bit. But if you guys, the two topics I have, we're talking really on a corporate level, the customer, the company that's maintaining this critical information. How do we protect these folks? What are the strategies to minimize liability? We've talked a lot about it, and the questions are directed that way. The second thing is the IT professional. What do we do for you guys to make your job right? There's this notion of IT professionals coming in, you do a pen test, you do whatever you may. And gee, oh my gosh, there was unauthorized access, or there was all these things that happened, and what liability is there? I just read an article. There was a guy arrested yesterday in Florida for an example that Jennifer gave in her talk, sitting out front, wiretapping and that type of thing. The IT professional, though, there's a real objective answer. You're running a business too. The difference between the people in this room, I assume, and the folks that we read about who are being prosecuted is you're doing it as a business. You want to make money doing it, and you want to do it correctly. And so, if you want to open that topic at 6 o'clock, or I'm happy to stick around and talk about it, a lot of it has to do with the context of the contracts, the confidentiality agreements you have, the letters of authorization you sign, and those types of things. And again, I don't mean, Brian, I really don't mean to have shameless plugs, but a lot of those are covered, and that's why we're here, is because of the things we covered in the chapter in our book. So, on that, I'll open it up because we're out of time. Does anybody have questions? I'm happy to stay around. If not,
I had one back to his original thing about national security policy and what we viewed as an attack on the U.S. And that was a few years ago. There was an attack on the 1,300 name servers that basically do all your name resolution on the internet. Lasted for about 3 hours, and then lasted for another hour, and it started shutting down the internet. During that attack, I think 4 or 5 of them actually failed due to the attack. How would the U.S. view such an attack that was generic on the internet infrastructure itself, if it was actually able to take out the internet? Would that be considered an attack on the U.S., or how would the policy view that?
Well, that's a good question, and there's no knowable answer to it right now. International law isn't really law in the sense that we think about it. The law of armed conflict is really a development over time of what countries are willing to do to each other, and how the rest of the world punishes countries that do something they're not supposed to do. So ultimately, a decision about whether an information security attack is an act of war and therefore justifies under international law a military or intelligence or technical response by the attacked company is a political judgment. It's a political, small p, judgment for the people who are in power at the time. Now, your question has 2 factors to it. One, how serious was the attack? Because you do have this obligation for proportionality. If Al-Qaeda, instead of striking the Twin Towers on 9/11, had blown up a tree with nobody in it, that probably would not have been enough to justify the kind of response that we gave in Afghanistan. So under your scenario, I believe most international lawyers, and I can tell you this administration, would say launching a denial of service attack that disabled the internet would be considered an act of war and therefore would justify a proportional response. Now, the second part of the issue, though, is who was it done to? Who was it directed against? You don't have the legal authority or the political authority or the moral authority to respond to an accident, let's say. Even if the accident happened in Russia, the fact that it happened in Russia doesn't give us the right to go and attack the Russians. So if the political leadership of the country decided that the people who launched the attack were intending to harm the United States, then we would be justified under international law. That would include if they were designed to harm everybody and the United States was part of everybody. So, when a NATO country is attacked, even if the United States wasn't hit at all, we've decided by treaty that that's considered an attack on us. Same thing here. You'd have to have some intent to strike the United States, but it wouldn't have to be an intent to strike only the United States. Does that make sense?
Yes, definitely.
Okay. Sir?
Brian, how receptive are you finding corporates to the message that you guys are delivering?
A lot more than they were 6 months ago. I really have been very pleasantly surprised because it's a very tough set of hurdles that we face, and I'm grateful to Forrest and our other partners for being willing to take this on when I joined the firm. Because you basically not only have to convince the company that they've got a serious problem that's worth the economic cost of fixing it, then you have to convince them that they need outside help, and then you have to convince them that the outside help ought to include lawyers. And it's a steep road, and business people are skeptical about lawyers, and they probably should be in a lot of cases. But I was a keynote speaker at a company's annual meeting that outsources IT to colleges and universities around the country. And I got there, at noon and gave a speech, and the next morning they were going to run all their CIOs through security training. And I give the guy a lot of credit. The guy who's in charge of training pops up his PowerPoint presentation. He shows 3 slides. He says, this is what I was going to tell you as of yesterday morning. And then he popped up a graphic of the red circle with the slash through it. He said, after our conversations with Brian, now here's what we're going to do. And really turned immediately and adopted our approach. Now, that obviously hasn't happened in every case. But I think the combination of the recent publicly disclosed problems and getting people to really understand why it's important to have that attorney-client privilege and why it's important to have attorney involvement, we're making some headway, and we got more work than we can handle. So.
What we didn't talk much about is the impact of the potential liability to some hardware or software providers for security breaches. Do you see any changes coming with respect to protection under the EULA and so on? And do you think that is going to change behavior?
I think, this is, crystal ball time, I think that the hardware and software providers will certainly be targets of the plaintiff's bar. And there's no question about it. When one of these things happens, everybody's going to get sued. It's going to be the company who was holding the information. It's going to be the company who built the software. It's going to be the company that built the hardware. It's going to be the people who installed it. The question then becomes who's going to win and who's going to lose. I think it's very, very hard, as we've seen in cases of gun manufacturing, to get corporations to be liable for products that were correctly designed but capable of misuse, and they were then misused. Now, on the other end of the spectrum, though, I do think there's a very serious risk of liability for software and hardware producers where they can be shown to have known that there were exploitable security flaws in what they produced, and they shipped it that way. And I'm quite certain those lawsuits will happen, and they'll be successful.
There's always the concept of the comparative negligence and contributory negligence, depending on what state you're in. And I agree with Brian's comments. I also feel that you're going to see situations where there was a recommendation, you need these types of firewalls, you need these types of peripherals, and they were not properly implemented. They were not properly managed. Part of the message that Brian and I are sending out that, again, is being better accepted is the idea that this is a process. It's not static. And that's what the danger we see in just somebody comes in, the IT guy says, we need a pen test. You come in and you perform it, and as the gentleman, I think, who's left pointed out, why is there liability for that? What's the matter? Well, the problem is it may not be for the IT professional, but you've got to be part of a system to keep the company meeting that standard of care in a changing legal environment.
Part of the problem you see is that individuals who are accountable at the end of the year when they say, well, what did we do this year? You let this year show,
right,
conducted a pen test, and to demonstrate all of the intrusion attempts that they managed to avoid because you can't identify.
Well, and that's one of the things that we believe is helpful. Companies can't just say, oh, here it is, wave the wand, and these processes have been tested, remediated, and everything is wonderful. And Brian alluded to it. If you start out, if you say our budget just doesn't allow it, if you start out and you say, let's implement a security plan, and it involves pen testing and upgrades of hardware and software, it may be a 2-year plan, but it makes a big difference if you're actively pursuing that plan and you're 6 or 8 months into it and you're on task, and now the occurrence happens that leads to liability, civil or criminal, and you go to the regulators, you go to the plaintiff's bar and say, look, we've known it, we're implementing it. You're way ahead of the game at that point, and so that's a way you can meet budgetary concerns as well.
Sure.
I have 2 questions, really. In the Citibank example, you talked about having control over third-party, your data and third parties. Does this go beyond the more generic non-disclosure? This is the first question.
I guess I'm not understanding the context.
Yeah, I don't follow you.
Well, we have a relationship with a third party, a provider. We have a non-disclosure agreement, mutual non-disclosure agreement with a third party.
I see what you're saying.
It doesn't say anything more than you shall not expose the information about us that we give to you.
My belief is that it's not going to be very long before there is a successful lawsuit which says I think Time Warner will probably escape it because they didn't have the Iron Mountain example to look at, so there was, they weren't on notice of that. But the next person, next company, I think there's going to be a lawsuit which says it's not enough to have a piece of paper which says, "Thou shalt protect my information." You also, at a minimum, I think, and this is what we advise our clients, have to have in the document, the agreement, it has to say, that meets the same security standards we meet, and it needs to give the other company some idea of what that is. So I think at a minimum it's going to have to be a lot more detailed than a non-disclosure agreement. I also think it's quite possible that the companies are going to have to build in mechanisms to enforce that, whether it's inspections or the ability to go look at, not to pick on Iron Mountain again, but that's the real example, to look at their books, to assess their procedures. It's just not going to be enough to say, go do the right thing.
There's a different set of liabilities to me, if I understand where you're at with it. A non-disclosure agreement is valid as between, say, the provider of information assessment and security, whatever that may take on, and the client. In terms of the client saying, hey, we have trade secrets, things that are of value to our business that we try to undertake efforts to maintain as confidential. So that's valid there. But the problem is that's not the key to the city. That does not give your client now a right to disclose all medical records if they're in that business you may have to seek court authorization under HIPAA to protect yourself. It does not give them a right to allow access to all of the software that's subject to other licensing contracts. Still may breach the contract, and you need to get consents. So, non-disclosure agreements are very important, but they cover a narrow band of what's being considered. And when somebody comes in, you need to say, what's the scope of what I'm being asked to do as an IT professional? And you need to look out and how am I affecting third parties? Because if you breach it, the one that's getting sued isn't you. You're getting your client sued, and of course they'll bring you into the lawsuit and seek indemnity under common law or otherwise. But you've got to assess it as a whole, not as a narrow area.
One of the things that, just to follow up on that real quick, one of the things that was in Forrest's presentation is also in the book too, is there just are a lot of things that as an information security provider you need to have in contracts with your customers. And one of the most important, as you all know, is letters of authorization. Because not only does that help protect you from criminal liability, because in most states the information unauthorized access laws say either you made unauthorized access or you exceeded the access you are authorized to have. So that's point number one, as between you and your immediate customer. But the other thing is you have to know, and I think lawyers can help you with this, you got to know what they actually have the authority to give you the authority to do. So for example, I don't believe a healthcare client of ours can sign a letter that would legally allow us to get protected healthcare client information. So you have to worry about protecting your liability against that in other ways, whether it's leaving a marker on the data instead of actually touching it, or whether it's getting agreements with the government or whatever. So that becomes a really important consideration to protect the information security provider, is what their contracts actually say. I think you had one more, but then we got to come back over here.
All 50 states have right now, not all of them go as far as Brian said and say exceed your authorization, but all 50 states have statutes in place that impose liability for unauthorized access to information. So, every state is different, and that's important, and it highlights that of all the issues that are floating out there that people are trying to wrangle in and deal with, that's one that hit the books early on, and it's becoming really clear. Letters of authorization are something that are very at the forefront of prosecutors' minds and others. And one of the things that I, as a corporate lawyer, sometimes I see these contracts and they're global. They try to contain everything. I think it's wise to have your agreement to provide services be one document, to have your confidentiality agreement be a standalone document, to have your letters of authorization attached or addended to it, but to be separate. Why? If you have an issue over a letter of authorization and there's 10 letters of authorization, you want that whole transaction to be submitted to the arbiter or the court. No, it's easier to deal with it. Or made public. Same with the confidentiality agreements. The remedy normally that people are seeking, and it can lead to damages, is adjunctive relief. Stop disclosing, do whatever, and then there may be damages. Well, you want to isolate it to that agreement. And so you do have to take these transactions, figure out what the provider is what services the provider will perform, what the client's needs and expectations are. And, you know, a lot of times it does become kind of a form set with some tailoring, but it is important to target what is the concern and not just try and lump it together in one contract and say, okay, sign this and I can get busy. That might work, it might not.
I think they're probably about to turn the lights out on us. Just let's do this one over here, then we'll come back to you, and then we'll be around all week, and we got business cards and stuff. Sir?
Do you have 2 or 3 quick guidelines that you could provide for those conducting security assessments for the U.S. government?
Yes. I have a lot more than 2 or 3. That's a real good news, bad news story. The good news is that the U.S. government actually does have not only the NSA methodology that they follow, but they have through NIST and through their form contracts, they lay out a lot of requirements for information security providers, which is good from a legal standpoint, because as long as you live up to the requirements that they've set on you as the customer, you've got a pretty good argument that you met the standard of care. So that's number one. Number two, though, is most people that are in positions in the government agencies to sign these contracts and then supervise the work are people who have 100,000 other things to do. And much more, in my experience, than in the private sector, you really, really have to be super careful to police yourself, because the customer is not going to have time to do it, but you can be sure if something goes wrong later, they'll blame you for it. And then the third thing I would say is have a very clear understanding when you get into, before you sign a contract with the government agency, of what information the government believes is specially protected and what isn't. That's important in the private sector context too, but pretty unusual that you're going to find yourself having access to classified information when that wasn't made clear to you up front because you had to get a clearance. But there are lots of other types of information now under the Homeland Security Act and other statutes that are protected, but the government itself isn't so good yet about understanding what those are. And you really have to, hopefully working with lawyers, but you really have to make sure you push that process with the government. You need that contract to say, here's what I'm expected to have access to and here's what I'm not. So that's 3 quick ones. Okay, let's do your last one and then we'll be done.
Yeah, I'm really intrigued with your model for protecting the information through the attorney-client relationship. Considering that I'm approaching this from the corporate side, and I'm not a consultant, but if I contract with you to do it, and you contract with someone to do an assessment, you get the report, and that is a confidential relationship. But now my auditors are going to come by and ask me what I've done to ensure the protection of my network. I have to expose the report to them. Is that
Well, the report comes through. Yeah, the report comes through counsel, but that doesn't mean that it's filtered or mitigated. I mean, what we're doing is saying we need these certain tests done so that we can help develop compliance plans and those types of things. But that's the information, of course. The client's always entitled to the information; they're paying the bill for it. So I don't, Brian can add, I don't think that it dilutes the access to information.
I'm not sure that's quite your question. I think if you're saying, what happens when outside auditors come in and I show the report to them, does that destroy the privilege? The answer to that is, well, it's a little bit of a complicated question, but if your company hires auditors, even if you're required to by law, to come in and essentially be a super third party, because now you've already had us as the third party, you hire them, they're contracting with you, they become your agent. So the fact that you gave it to them is not going to destroy the privilege in most cases. Now, on the other hand, though, if you're talking about like government auditors, if somebody comes in against your will and demands information and you're under a legal duty to provide it, then that can damage the privilege.
And you could do summary reports. A lot of states, including Colorado, which is our home state, have CPA privileges with the client. So that's an additional layer of protection when they're doing the audit, and then the question just becomes, again, very similar to the attorneys, is it waived and under what circumstances?
And by the way, the other thing you can do too is when you bring in those other if you're contracting with outside auditors, you run that relationship through the attorneys also, through the law firm, and then it's absolutely, I say absolutely, it's protected just like the first information. There are exceptions to the privilege. As I said, you can inadvertently waive it, but it gives you pretty powerful protection.
As an SEC-traded company, we can't, or an SEC-regulated company, we can't, we have to have public audits.
Right, but I don't think there's anything in either the statute or the SEC regs or any decisions I'm aware of that would prohibit you from having those auditors report to attorneys. Now, the auditor's report, of course, will be made public, and that's not going to be privileged. But you hope by then, by going through the third-party process, you're going to be in pretty good shape by the auditors.
There's routine legal information. I mean, I routinely do audit letters for our clients. Give us all outstanding claims in excess of, the amounts of determined liability. And you give that information, and you disclose any outstanding contingent or existing liabilities, and that doesn't waive the privilege either. So, I mean, I think you can give factual information that is sufficient for the auditors to do their job without destroying the substance of the attorney communication in that regard.
Thanks, everybody, for sticking it out well into the cocktail hour. We got some cards up here, and we'll stick around. Thanks.